keep on coming. Even after 90 days from the ICD days, you keep on receiving claims. Then perhaps resolution you file, you publish Form G, you call for invitation of interest, then resolution plans are considered, then resolution plans are approved. So, this process, while it is going on, it is quite possible that even during that time, you will have some or the other claims which you are receiving. So, the question is that what to do about these claims and whether these claims are liable to be admitted or rejected, or whether this confusion will continue to be there, that whether to accept it, whether to reject it, whether the NCLT will accept it or reject it, because the resolution applicant also takes certain decisions on that basis. So, what is to be done? Then, all right, resolution plan, what happens thereafter? That Form G is published, expression of interest is called for, people give their expression of interest, then resolution plans are called for, they approve, the COC starts considering multiple resolution plans. Sometimes what they do is they feel not working out, they don't like any of the resolution plans that they receive, or nobody files the resolution plan. Though they have put in interest, they don't file the resolution plans in time. So this has happened in most cases. The resolution plan is not accepted, they go back, timelines are extended. Now multiple beyond 330 days also times are given if you are able to show the right reasons. They again call for a fresh Form G is published, multiple Form Gs are published, again claims are, against resolution plans are called for, and this process continues. And finally, after say a switch challenge, or after discussions with different resolution applicants, finally one resolution plan is approved by them. Okay, so that is the approval of resolution plan by COC. So now, while this process is going on, you may keep on receiving various claims. Now, what you do once you get an approved resolution plan from the COC, resolution professional is bound to put that resolution plan before the NCLT for their approval. Now, in certain cases, we have received that approval within 1 month. There have been cases where immediate approval of resolution plan has been done within 15 days time, and there have been certain resolution plans which are pending. Now, for instance, in one of the matters that we are doing, there are more than 15 objections which have been, and this is in certain cases, this is less, but there are 15 significant objections to resolution plan which has been received. So now this resolution plan, before it is considered, like we had DHFL matter in Bombay, where there were about 15 20 different objections. Initial, there were hundreds of applications who were objecting to the resolution plan, but 15 20 significant stakeholders or dissenting financial creditors, certain other parties who had challenged the resolution plan, promoters who had challenged the resolution plan. So what happens is, even though the resolution plan is filed in the NCLT, you will see that, like in DHFL, the court took a call that I will not hear the DHFL resolution plan first. I will hear the objections. So out of the plethora of applications which were there, they took up the major objections because certain objections were similar. So they took up the major objections. All the hearings were concluded, all the pleadings were completed in all the matters, and then the resolution plan was finally approved by the adjudicating authority. So, similarly, when there are objections, the plan may drag. So, it has happened in certain cases that plan has been approved after few years because of the objections and because of the complications created by certain objectors. They make some or the other, they show some or the other statement in the resolution plan which is wrong. It goes back and forth. So, multiple complications. Okay. So, this is typically a CIRP process in practice. We have seen a CIRP process, the model timelines shown in CIRP regulations, but those regulations, those timelines in practice may or may not always be possible because of certain X factors that come in several litigations, right? The the size, for instance, in Bombay, we had a matter radius. in which I think Adani Group had invested, or there was this Radius Group was a huge matter. So in that matter also, the hearings took place for one particular resolution plan over a course of 1 month. The court was continuously hearing different objections over a course of good 1.5 2 months. So that way, in practice, these timelines are different. In reality, these timelines are different. So in this context of the CIRP process, the question was, what do I do with these claims? What used to happen is that who are the claimants also made a difference earlier, because if it is government revenue, or if it is some significant like PF, right now we are not getting into the PF related Jet Airways and Mozarbear judgments, but PF related issues, or government dues related issues, or GSTs, or in certain cases GST said that there's a fraud committed by this company and significant GST money has been they have not disclosed, and GST payments are due from them. So in all these cases, how how are these claims to be dealt with? Till yesterday, we had only Ghanshyam Mishra judgment, which was to certain extent clouded by the judgment of Rainbow Papers. So we will come to all that once we get into the specifics of these judgments. Okay? Are all of you clear? Have I put you all to sleep?
Please go ahead, madam. Thank you.
Okay. I will need a little interaction from your end, okay?
Might be due after lunch, somebody might be
I know,
napping.
I know. This is the most difficult session
Might
to
be some
take.
napping.
2 to 5 is for watching movies. But trust me, when you come to court, it is like a movie. So there are villains, there are heroes. So that is the thing. Okay. So type of claims, as we all know, financial creditor, creditors in a class, workman, representative, other creditors, right? So tell me, what has been, how have you dealt with certain claims? Have you faced some problematic claims which you dealt with, which you didn't know which class, or anybody has some inputs to give on this angle? Anyone? All right. So some of the claims, as in claim
Can you
related
can you can you give some example of other claims, other creditors
other creditors,
who are required to file Form F? Can you give some example,
yes.
please?
For instance, if you have, say, an interest in land, you have like a right of way or an interest in land, leasehold rights. Operational creditor deals only with goods and services, correct? So if you have certain interest in land for which you are paying the corporate debtor, how will you categorize it? That will be something which will come in other creditors.
Lease rent.
Yes, lease rent.
Okay.
See, the license fees is different, but
Okay.
lease, there have been judgment which says that lease is. See, I'll tell you, the case laws keep on changing. Okay, so if it, say for instance, for right of way, sometimes companies pay certain fees. Okay, so that kind of payments will come under other creditors. Then other stakeholders file under this. For instance, preference shareholders, they will file under F. They will file as other stakeholders. So those are the people who will file, who do not fall in this operational creditor, financial creditor category. They will file under other creditors. Anybody has any example they can share?
Prachi ma'am, I have one experience. Although I was not part of that CIRP as an RP, but
Mm-hmm.
I was an advisor to few home buyers,
Okay.
and that was, I don't know whether you can guide or you have an practical experience on that. The home buyers had to file a claim and there was two components. Firstly, the payment was made to check in through check and RTGS, and second, typically a builder sometimes asks for cash component, that is especially some internal work related, or some work, additional work has to be done to a particular property or a flat. So cash component was there, and the challenge was how or whether to accept the cash claim or not with the RP. So that was some bit different experience other than a routine claim. So cash component and their admissibility.
Cash claim is difficult. Court will not accept because that is like
And
agreeing to an illegality. What happened in that matter?
In flat
uh,
buyer, there might be lakhs of rupees cash, but more than 10,000 it is not allowed.
Correct. So I think that aspect, the court, if they start allowing that, it will be a complication. So
so
that's
just
why,
as
but
you
see,
yeah.
anybody who has seen the practical side of things will understand all these problems. But if you start allowing this, it will be, you will be opening the floodgates. There was
Yes,
one
I
more,
agree.
there was one more matter in which there was a builder, okay, based out of Maharashtra. The flats were given in one company, which went into CIRP. The money was taken in another company. So money has gone to a partnership. The money has been siphoned out because when it comes to NCLT mechanism, no action can be taken against the partnership. So monies have all been taken by the partnership, and the allotment letters for the flats have been given in the main company. So these kind of complications, you have rightly said that these kind of complications are there, where the RP has to decide कि Baba, no money has come from this home buyer to the company. So should I even accept the claim of these home buyers? The home buyers is one complicated area where all these problems come. One more problem which we had faced in one of the problems, one of the cases was that how do you sell the land? People generally either enter into a development agreement with the landowner, or they purchase the land from somebody by purchasing the company. So now company was purchased by a builder from landowners. Okay. Now this a builder, what he did was he purchased the shares of the company for transferring this land. Against that, he promised them allotments of the flats. There was no monetary consideration. So RP is saying there is no monetary consideration, and you are a promoter. So I am not putting you in the category of creditors in a class. You are not a home buyer. So this issue went up till the Supreme NCLAT stage, still pending in NCLAT. There are some judgments where whether a landowner can also be a home buyer when he is not paid as a home buyer. All these are complicated questions. So when it comes to type of claims also, you will find that there are multiple problems which arise. Okay.
Madam, I have query on claim. Since we are discussing claim,
Mm-hmm.
not in case of CRP, in case of a voluntary liquidation,
Mm-hmm.
typically you might be aware that director's home is given
Mm-hmm.
as a registered office of a company at the time of formation of company.
Correct.
In this case, for 2 years there was a lease agreement,
Mm-hmm.
and which got expired.
Mm-hmm.
And another 4 years there was no agreement, there was no claim asked for, nothing was there.
Mm-hmm.
After 4 years, that is in total now 6 years have gone. 2 years rent was paid, 4 years no demand was there, no agreement was there, nothing was there.
Okay.
And when the company went into liquidation, the owner of the property has filed a claim stating that you have been using this as a registered office address. Practically, the company has not done any activity, but in government records or everywhere on the letterheads, in the communication, everywhere, the address has been highlighted as registered office address. Company management did not change the address.
Hmm.
And now she has filed a claim uh, to the tune of 1.5 crores. That includes the rent, the penal provision, and interest, and everything.
Hmm.
So, what do you advise on this?
See, advice I'm not going to give in today's
Or do
forum.
you have any practical experience on that?
But the practical experience is somewhere the RP has to take a stand. It being a voluntary liquidation, ultimately, you need to take a stand. Where what is like, is this a cantankerous litigation where between shareholders also they are not seeing eye to eye, or they are seeing eye to eye? then you discuss with them. Have an internal mechanism where you discuss with your shareholders, because I think creditors and all must be, are there lots of creditors in this voluntary liquidation?
No, 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 no. In fact, surprisingly, I'll tell you. Firstly, there was the agreement, lease agreement has expired. Secondly, if you see the financial statements of four
So I
years,
understand. See, so
there is
right
there is no
now,
provision in financials for liability.
so you have answered your own question.
Yeah.
So documentary evidence he is not able to produce. Other evidences he is not able to produce where there has been an agreement to pay. ठीक है?
Yes.
But because he has filed a claim and ultimately your voluntary liquidation process will drag, you have to take a call on that, because as
Correct.
long as other creditors are paid, ठीक है? And if
Yes.
whichever company goes into voluntary liquidation, they generally try to clear all outside creditors before they venture into it.
Correct.
ठीक है? So that call you have to take, which will be to certain extent to see how quickly you can close this liquidation, which will be which will be the basic thing which every shareholder would want. Between that, you will have to take a call, because technically, if you ask me, in voluntary liquidation, that claim acceptance rejection ultimately will depend on the facts and the documents, and
Okay.
whatever oral assurances, if they are there, and if there is any recording email or something, you will have to see that. Okay,
Okay. Thank you.
you're welcome. So now we have seen types of claims. Okay, we have seen the timelines, we have seen the type of claims that are there, right? As we have discussed, that 90-day window for the admission of belated claim is there with the RP. Now we came to the next point, is whether all these claims which are filed, different types of claims, within how much time do I have to accept it, whether even after 90 days the RP can accept or not. This was the question earlier, because earlier some NCLT said that why aren't you accepting these claims which are coming, why just for continuation of 10 or 15 days, why are you coming? So now the law which has been laid down in RPS Infra versus Mukul Kumar, and one more judgment, which is this UTGST versus Rajiv Dingra judgment, extremely clear that RP cannot go beyond that 90-day window. They will have to go back, and I'm just reading that relevant paragraph for you, which has given complete clarity to this issue. Okay, I'm reading para 44 from Rajiv Dingra's judgment. Okay. From the plain reading of the CIRP regulations, RP can accept the claims as per the extended period as provided in CIRP regulation 12.2 after extended period of 90 days of the insolvency commencement date. IRP is not obliged to accept the claim. Prima facie, CRP regulation has not provided any discretion to the RP for admitting their claim after the extended period. Had they submit their respective claim within the extended time frame and RP had not chosen to collect their claim, then they could have said that there was some material irregularity, because they claim that we had filed the claim but RP did not consider. Even if it was after 90 days, considering it is an authority and authority's payment should have been considered. That was the kind of allegations which were raised against the RP. So the court has come to the rescue of the RP and has made a very categorical statement. This is a NCLAT judgment by Justice Bhushan, and Justice Bhushan has delivered some excellent judgment, brought a lot of clarity, and also tried to see that resolution is possible. He has passed a series of judgment where resolution, he has been sitting along with Justice Mitra, and they have seen that the law of IBC is enabling and not hurting the resolution process. So while doing that, they have also taken care that RP and his powers have also been clearly defined, where they say that RP commits no wrong when he rejects a claim beyond 90 days, whoever has filed the claim. If he rejects the claim, they have to go to NCLT, and that issue will have to be decided there. Right? So, this is about the period of 90 days, and it is not directory. Whether it is directory or mandatory, the NCLAT has clearly recorded that it is mandatory, that RP is not obliged to accept a claim. So when RP does not admit the claim within the extended period, he does no wrong. So ultimately, beyond 90 days, you can simply reject. there will be no repercussions on the RP after this judgment of Rajiv Dhingra. Okay, so this is the first point in those series of judgments that we are doing. Hmm?
Madam, this is there are recent amendments
Hmm.
to Regulation 12,
Hmm.
where you can accept it up to the date of RE sorry RF RP or 90 days from commencement of CRP. That is recent
Hmm.
amendments.
But that is not dealt with this case law. So if it is extended, and that we will come to, because that will be overridden by this judgment, which we are going to deal with right now, which is the Mukul Kumar judgment. Okay.
Okay.
Yeah, just 1 second. Huh? So I'm just reading out this judgment for you. So right now, if that 90-day, because this was becoming a problem, as I didn't get your name. I didn't get your name. Who right now? Well, I'm
Right
just
now, I have asked Pradeep Samant.
Pradeep ji. Okay. So Pradeep ji, if this regulation now changes from 90 days to RFRP, this judgment will be overridden by the Supreme Court, because ultimately, again, the law will have to be reseen. Because if you see Rajiv Dhingra and Mukul Kumar, what they are saying, not till RFRP. If you remember, prior in time, it was till expression of interest. Then the law was amended to say you can't file claims till expression of interest, but you can file claim up to 90 days from insolvency commencement date. So these timelines are going back and forth as to till when the resolution professional can admit. So even if it is till the RFRP stage, whatever is permitted by law for the RP, he will have to, he has the right to reject any claim after that period. He cannot be expected that because it is by Mr. A or Mr. B, or it is a government debt, that you should have considered admission. You have the liberty. If it goes beyond the period provided in the regulations, it is a mandatory regulation and not a directory where the timelines are flexible. So
Prachi ji, can you clarify the current status of this GVAT claim? Well, whether they are still admitting as a secured creditor or only like
just GVAT or MVAT or other VAT?
Gujarat VAT?
Only Gujarat VAT, na?
Yeah, yeah.
See, a rainbow judgment has to certain extent. There are fresh judgment which have to certain extent reduce the impact of the GVAT judgment. Now, for GVAT, what they are saying is they are trying to distinguish that judgment. Let us go to rainbow papers a little later, because rainbow papers is a full day affair. So
Okay, just
we,
I
I
want
would,
to,
yeah.
I want your answer
GVAT, see,
in one
GVAT,
line.
I'll give you in one, I'll give you a one liner. GVAT, you will have to see whether they have already initiated recovery proceedings before the insolvency commencement date for recovery of the properties, or that recovery proceeding where they have already initiated. If they have initiated, you have to see in the claim there's a provision where they say that whether there are charges or not. So if
Oh,
these two things are done, then that section 48 will apply, and you will have to consider them as secured creditor. Okay, but
if
if
proceeding,
the recovery proceedings
if
under
proceeding
48,
has not yet started, then
then that issue, right now these judgments somewhere have whittled it down, as in if that has not already started, because you cannot initiate proceeding later on, and that section 14 and everything. So it is not clear from one judgment, but in a series of judgment you need to see how to deal with it. Okay.
okay, thank you.
Yes, but Rainbow's paper still applies, but to certain extent diluted by all these judgments which have come subsequently. You can even read Mukul Kumar's judgment, which we are going to deal with, which again deals with the belated claim which was filed in Rainbow papers, and said that that cannot be the rule. Okay.
If NCLT direct RP to admit this claim in line with the rainbow judgment, then what RP should do?
When will they admit it? Have they filed it in time?
Yeah, that is, timeline is not an issue. Only the issue is the secured creditor or unsecured creditor, OC.
Have they initiated proceedings earlier?
No,
Then rainbow paper, you might have to talk to your lawyer to distinguish that particular thing, because in
if
rainbow paper it was
NCLT has passed the order that RP should decide its claim in line with the rainbow judgment. That's
no,
it.
no, you have to decide it as per the rainbow judgment, correct? Rainbow
Yeah,
judgments go through the facts and distinguish your case with the facts, then you will get your answer.
they are same. The facts of the case is
No,
same.
no. Recovery proceedings. That's what I'm giving you that answer. No, you
Okay.
check whether recovery proceedings were initiated, action was taken prior in
Okay.
time to the insolvency commencement date. Okay?
Okay.
All right. Okay. So, uh, we again coming back, claims and timelines regarding claims and rejection of claims. So, in this particular case, now this judgment will be extremely useful for all RP. So, we will just see the basic facts of this judgment. Now, we are still on the part of claim admission rejections. Then we will move on to post approval of resolution plan. What is the status of the claims? So, in this judgment, just to give you an exam, just to give you basic facts, that this was the CRP process of Radha Madhav Corporation. This had started on 22nd October 2010-20. Last date for filing claims was November 2020. 90-day was 24th Feb 2021. RP informed the office to submit their claims, and this went in favor of the RP. That though RP is not required to call for claims and to write to various creditors, in this particular case, the RP had informed the tax authorities that you should file your claim, and the authorities but now the authorities are now taking actions regularly. So I think what has been the experience of others? Are tax authorities duly filing their claims?
Yeah. Now they are,
Yes.
they
Yes.
have become aware about this enactment of IBC. Earlier they
Correct.
didn't know
They are
what is
filing.
NCLT, what is IBC, nothing. They only knew only this IT80. That's it.
Correct. And my experience has been that they are completing assessments also quickly. In cases where they find that CIRP has started, they are completing assessment also in time. So, best case, best judgment, based on that, they are filing their claims. What has been your experience? Assessment and everything has been done, and fresh claims filed after the after the CIRP commences.
Yes, they are filing in time.
Okay, okay.
Many times what they keep, I think my experience is they have a specific team or department which keeps track on newspaper advertisements,
Hmm.
and whenever an advertisement is published based upon the alphabets or address, they
Hmm.
contact the concerned jurisdiction officer and they advise him to file the claim with RP.
Okay, okay. All right. So that is one part of it where they are filing the claim if they know that some amount is crystallized, they are filing it. Okay. But the other part is that sometimes their claims are not assessed, as in they don't know how much is to be crystallized. So technically, what the GST department should do is they should assess what is the amount, because as you know, RP can consider contingent claims also. One is a claim which is decided, and one is a claim which is contingent. What is the contingent claim? We'll just see the definition of claim. Just give me 1 minute. I'll just open that. Pause. Yes. So, has any one of you accepted a contingent claim? Anyone? All of you have. Has anybody accepted a contingent claim?
Yeah, it was initially, but it has been converted into this confirmed claim after getting the sufficient document. Unless we receive the sufficient document in support of the claim, we should not admit.
No, but that is substantiation of claim. But
Yeah.
what about, say, for instance, if there is an arbitration proceeding which is
Yeah,
going
if
on?
arbitration, some award is pending, or some if award has come but he has not filed the
What if award
copy,
has not come, but they have still filed their claim?
then we will admit as a contingent unless we receive the copy of award.
Right, right, right. So, contingent claim, even I think, but GST department and all these tax departments are not following it, because I think internally, I don't know whether they are permitted to do that. So, this is the same problem that happened in this Deputy Commissioner UTGST Daman, that what they tried to do is, here, if you see, the Assistant Commissioner had submitted their claims relating to the penalty imposed on corporate debtor of 37 crores. So during the insolvency commencement, on the date when insolvency commenced, they had one claim, but they had not assessed the quantum of penalties and other claims which the corporate debtor should pay. So what they did was, after the CRP commenced, they started assessment proceedings. They completed the assessment proceedings, and in that they found that 37 crore is payable as penalty imposed. Okay, so this claim thereafter they filed. During that time, what happened is resolution plan was approved on 2012-2021 by the COC. So if you see, this claim was filed in November, and resolution plan was approved. I think this date is incorrect. Thereafter the resolution plan was approved, so they filed after the approval of resolution plan, if I'm not mistaken. I think this date has gone haywire. They had filed it after the approval of resolution plan by the COC, but before the approval of resolution plan from adjudicating authority. Okay, so the question which came before the court was that whether resolution, just one second, whether any material irregularity has been committed by the RP and the COC in rejecting the resolution plan, which was a different aspect altogether, and whether on account of rejection by the RP of the claim filed by GST, resolution plan does not meet the requirements of applicable law, because resolution plan requires that you comply with all the laws. So the GST department raised an objection to the resolution plan, saying that you have rejected my claim which I had filed. Though it was belated, I had still filed my claim. So therefore RP has committed a material irregularity in rejecting my claim. So the court said, and I have read that portion, that there is no material irregularity. From the plain reading of the CIRP Regulation 12, RP can accept only after that, between that 90-day window. RP is not obliged to accept the claim, and therefore CIRP regulations has not provided any discretion to the RP in admitting their claim after the extended period. So you will have to go to NCLT, get the approval, and only if the NCLT approves your claim, only then you can do it. I think in this case they did not go to NCLT, they simply challenged the resolution plan, because till that time resolution plan had been approved. So court said nothing doing, you have come afterwards belatedly, so this will defeat the objectives of CIRP, because if the resolution plan has to keep on updating after IBIX, you cannot modify a resolution plan. So if you keep on changing the claims, then the resolution plan also might be affected because of this. So after the COC has approved, we are not waiting till Ghanshyam Mishra, where they said that after approval of resolution plan by adjudicating authority, nobody can file claims. They said even if resolution plan has been approved by COC, even if that application for adjudicating authority's permission is not filed, even then you will have to, your claim goes away. So this judgment in Rajiv Dhingra says, and now it is the law, that if you file a claim after 90 days, RP can reject, number one. And the second is, if you file a claim even after approval of COC, but before approval of adjudicating authority, your claim still goes away. And we'll just see the timings here. So, claims received. This claim received after 90 days, but before resolution plan approved by COC, court in this Mukul Kumar and in this Rajiv Dingraj matter has said that during this period, yes, if your claim is rejected, come before the adjudicating authority, you stand a chance. But if you come after approval by COC, then you have lost. After resolution plan is approved by COC, we are not going to consider any claims which have been filed after that. So the first clarity came during Ghanshyam Mishra's time. The second clarity, as we have seen, I'll just show the Ghanshyam Mishra judgment. What did Ghanshyam Mishra say? Ghanshyam Mishra said that Section 31 provides a clean slate. It is binding that if the resolution plan is approved under Section 30 by the adjudicating authority is satisfied, then the plan shall be binding on employees, members, creditors, other stakeholders involved in the resolution plan. So the first clarity in when you can reject the claims and after which stage no fresh claims or no old dues can ever be sought was given by Ghanshyam Mishra's judgment.
Actually, this is already written in the statute code itself, but it is just an extension of this statute.
Absolutely, absolutely. All the judgments have expounded whatever is written in the law, because the Supreme Court will not be able to create new law. It is just trying to elaborate what the code means, right? And as you rightly said, that this was the real import of Section 31, that once resolution plan is approved, it is binding on each and every authority. And the court has said that when Section 31 talks about creditors, and you will see here, Supreme Court finally upheld the clean slate theory and clarified that successful resolution applicant will be required to proceed with existing claims and no fresh claims can be imposed on the successful resolution applicant post approval of resolution plan. So this is where they have made a clear cut statement that after approval of resolution plan by the adjudicating authority under section 30, section 31, it will become under section 31, it will become binding on all. So what they said was that section 31(1) of the IBC do not specifically state about central government or state government that it is bound by the resolution plan. However, if you apply harmonious construction, operational creditor, operational debt will be included, and therefore the section 31 also says other stakeholders. From that also you can infer that central government, state government, other authorities, tax authorities are covered within the ambit of section 31. So nobody, not even the state government, nobody after approval of resolution plan by the adjudicating authority can ever claim any amount which is a pre-CIRP amount, right? So this was Ghanshyam Mishra. The same thing was earlier elaborated in SR Steel versus Satish Gupta, where they have used that Hydra head, where they said you can't have undecided claims, you cannot have Hydra heads popping out of the sea after the resolution plan has been approved. So all these new things cannot be done. You cannot put the resolution applicant in a situation where he is dealing with something which was never there before the resolution plan was approved. But both these judgments only spoke about post approval of resolution plan by adjudicating authority, and they spoke about section 30 and section 31. And that was where there was a small issue. Why? Because people used to say that look, Ghanshyam Mishra SR Steel talk about approval by NCLT. We have filed our claim before approval of NCLT. In NCLT, the matter was pending. So during that time, we have filed our claims and you're not considering it. So this issue has been resolved by, and this I have just put the timeline. So 90 days before COC approval, after COC approval, before filing of section 30, after filing of section 30, status of claim, before AA approval. So we have seen that before AA, after AA approval, clarity, because of which judgment, Ghansham Mishra and SR. But what about before AA approval? This was an area of certain, it was a gray area. So there were multiple different types of judgment which were being passed. Because it is a claim approval related, many judgment did not reach the higher courts very fast. So but now clarity has been given even with respect to that. So what is the clarity? That after the third point, that is approval of COC for the resolution plan, all these things before AA approval and after COC approval, this entire 1, 2, 3, 4, 5, the last 5 portions, you will not be able to file a belated claim during this stage, and if you file, your claim will be rejected. This is the current law as has been laid down by the judgments which have come this September. This one is Rajiv Dhingra. Number 2 is RPS Infra versus Mukul Kumar. Same issue. The only issue is whether in this case, what was happening is arbitration proceeding was going on. There was an arbitral award, but that was an appeal. So the party failed to file their claim saying that I have an arbitration proceeding going on. So why do I need to file a claim? So court said two things. One, even if it is an arbitral proceeding which is going on, it is a contingent claim. So you ought to have filed the contingent claim, number one. And number two, as you have filed this claim, after the resolution plan has been approved by COC, sorry, we can't help you. Your claim is liable to be rejected for being a belated claim. So this clarifies, as I told you, these three last 5 points, that what happens after COC approval till the time what happens before AA approval, the claim status of belated claims which are filed during this period. Now let us go to the Tata Power judgment. Now Tata Power. How many of you have witnessed any? Are we clear on this point?
Yes, we are clear. So practically there cannot be any dispute after approval of resolution plan.
After approval of resolution plan, earlier it was after approval of resolution plan by adjudicating authority. Now it is approval of resolution plan by COC also.
Correct.
So
So we are experiencing various matters in NCLT even after approval of resolution plan. So
correct.
those are regarding challenging resolution plan only, or disputes
No,
relating to property or something.
no. This only is regarding claim rejection.
Okay.
This doesn't deal with objections to resolution plan. See, objections to resolution plan are multiple. One is that my claims have been rejected is also an objection to resolution plan. For instance, if you reject the claim of some financial creditor, or you don't consider them, you consider them to be related party, they challenge the COC constitution. That is different. This is regarding regular claims, as in if you see certain companies, they have like in some matters 30,000 claims have been received, and they keep on receiving claims over the time. Even after resolution plan is approved by COC, they used to keep on receiving claims. So this issue has been clarified. Rest of
Okay.
the issue we will have to look at judgment, we will have to see. But these two judgments have brought complete clarity now.
Okay.
As on date, let me put it as on date. Both these judgments are, as you see, this is the RPS Infra is a Supreme Court judgment. So complete clarity on that portion, right? And if you read Mukul's judgment, Mukul Kumar's judgment, you will also see that they have dealt with. I think somebody had asked a question about rainbow papers. So just see, I'll give you the relevant paragraphs in the group in that chat box regarding RPS Infra. There they have dealt with rainbow papers also. So you might want to take a look at this judgment, right?
Okay.
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 Okay, okay.
Okay. So now let us go to post approval of resolution plan. So by the adjudicating authority. So for instance, we are facing in few matters that it is not easy to implement resolution plan. I have appeared for several resolution applicants, and it is easier said than done. As I think I do a lot of mergers and amalgamations. The thing is, it is easier to get an order to say that okay, merge two companies, but it is much more problematic in reality. I think there are many chartered accountants, company secretaries who are IPs. I think they will agree with me on this point, that it is easier to get a merger order saying that okay, merge two companies, but it is much more difficult in reality to implement that order. Is it true? Anyone has experienced that? All right. So, like because we have handled mergers, what happens is it says कि बाबा all assets are together, all liabilities are one, but in reality, it is a complete complication. Even employees, the name changing. For instance, you are today a part of A company, today Z and Sony. If you are a part of Z company, and today you have to consider yourself to be a part of Sony, there will be changes in the policies. Who, what is the hierarchy? What is it? So all these things change in any merger. So similarly, in case of resolution plan approval is the easiest part. Because of all these judgments now, approval of resolution plan is easy. But post approval of resolution plan, many people face multiple complications. So
That
let
is
I
true.
have
That marriage is easy, but after getting marriage, the adjustment is very difficult.
rightly put, absolutely. Absolutely. I think I couldn't have put it in a better way. You're right. The
Thank you.
hap- so happy endings don't end. What they show in marriages, that the people got married, two people met, fell in love, got married. Nobody shows the story thereafter. The main story lies there. So similarly, approval of resolution plan after approval of resolution plan, what happens? So just to give you some details, and then we will go back to the Tata Power judgment. What are the problems that I have seen happen in implementation of the resolution plan? And all of you can also chip in your experiences, because see, in these sessions, if we are able to, everybody has different kinds of experience. So the more you share your experience, other people will also a- anticipate that such kind of problems will come for them and be ready, right? So even if whatever is a smaller or problematic experiences or good experiences in implementation of resolution plan, or some strategies which you used which help circumvent this, those, if you have anything, keep that in mind. And after some of the implementation issues which I have faced, thereafter we will consider the issues which have been faced by some of the RPs. Okay. So number one problem in after any resolution plan has been approved is essential connection of essentials. Electricity is one of the main problems which many successful resolution applicants are facing. Many people take the company, they go to the power company, they say please give me electricity company shows them that entire arrears. They say please look at our regulations. We are governed by our regulations. Our regulations say that until this old arrears are not paid, we will not be able to help you. We don't understand NCLT, we don't understand your order. Please see our regulations and follow our regulations. They, on top of that, also say that what does NCLT order says? Comply with the laws. So what do the law says? Ki you have to comply with this particular regulations. And what does the regulations say? Pay arrears. So that way, many power companies were trying to arm twist successful resolution applicants by making them pay for arrears. So now this issue in one of the cases went up to the went up to the Supreme Court. So now what did Supreme Court say? Supreme Court said something very interesting. Let me just see if I have that particular, just hold on. Because this is very, very important. Every resolution applicant faces this. This is not new. Supreme Court has very nicely made a distinction. Okay, this was Justice Khanna. He's one of the. He has really given this classic judgment, wherein they have said that you will have to comply. This is the judgment. Because what electricity companies used to show is they used to show NCLT decision which says comply with law. They used to show the regulations. They used to show that regulation require payment of arrears. So you comply with this law requiring payment of arrears. So indirectly, they were trying to override the Ghanshyam Mishra judgment and make you pay for the arrears and give a complete go by to the clean slate principle. So this issue came up in multiple matters, and what court said in this particular matter, they have also given these two other judgments where similar orders have been passed, where they are saying that Tata Power, which is the power company, cannot insist on payment of arrears, which have been paid in terms of the waterfall mechanism or for grant of electricity connection. So they have made a categorical statement that power company cannot arm twist the successful resolution applicant into paying arrears. Then, with regard to compliance with laws, they have further said, however, successful resolution applicant will have to comply with all other requirements for grant of electricity connection. So the clean slate principle will stand negated if the applicant is asked to pay arrears payable to the corporate debtor for grant of electricity connection. Got it? So the Supreme Court has found the answer to the problem which power companies were raising, that we have to comply with the law. They said yes, you have to comply with the law, but you also have to comply with Ghanshyam Mishra and section 31 of the IBC, and this clean slate principle will be given a complete no go by. And therefore they have said that all other requirement, if you have to give additional forms, you have to give additional affidavits, additional undertakings, all those you can take, but the only thing out of your regulations which you cannot insist upon is for payment of arrears. Got it? Now, how have some resolution uh, applicants resolve this issue? So an easy way today is, rather than going through this rigmarole and going all the way to the Supreme Court, what people are doing is, because this comes in NCLT and NCLT says you have to comply with the law. So there have been conflicting judgments earlier, and that's why the Supreme Court judgment is very, very important. So what people are doing is they are taking new connections. They are not asking for reconnection. So people are not saying reconnect my electricity. They are saying you give you apply for a fresh connection. So if the SRA applies for a fresh connection, then these complications do not arise. Like to certain extent, they are resolved. So has anybody had that experience where instead of reconnection, you have asked for a new connection? Anyone? Am I audible?
Yes.
Okay. Has anybody has any experience in this? Hello?
You can please continue.
Yeah. Okay. So anybody how many of you have seen a resolution plan being approved? Have you gone through that process of implementation? Have you been a part of the monitoring committee?
Yes, yes. I was part of.
Okay. So, did you face any problems in implementation?
There were certain challenges.
Like,
It was a real estate company actually.
hmm, okay.
So the bankers were not there.
Hmm.
Statutory dues, there were hardly any statutory dues. So
Okay.
those challenges were not faced.
Okay. Okay.
Yeah.
Okay.
But the challenge, there were certain claims which were received even after the resolution plan was approved.
Okay.
That challenge was there.
That I think is a challenge everybody faces. They
That
they keep on receiving claims.
uh,
I think RP must be receiving claim even after 2 years.
yeah, I'm still receiving the claims and queries.
True, true.
But in home buyer case, it's a very peculiar matter because you cannot ignore such claim. It's a huge amount for a hardened this. It's a very hardened money and running into more than 50 lakhs, 20 lakhs like that.
Yeah,
But
And
it becomes a social issue.
but timeline has to be the adhered, na.
yes,
Obvi-
that is true. But
It cannot be endless. It is more than 2.5 years. The plan was approved.
but many home buyers are not that much literate in terms of like filing of claims and everything.
Correct.
Then they have
That
to.
is that's
I don't think literacy is the concern. There may be.
No, but I'll just tell you in one of the matters where some 200 odd home buyers had not filed their claims, the NCLT had said that look, RP can admit the claim if it is shown in the balance sheet. So there have been such judgments also where the RP was asked that why didn't you file it if it is shown in the records? Why haven't you done it? So
But
see,
yeah.
I'm telling you, we will not get into the debate because multiple
One thing,
judgments.
in our case, it was very safe because
Hmm.
we had made a list of unclaimed also,
Okay,
unclaimed home buyers. So,
okay.
so that was already there. And in the
Mhm.
resolution plan, they had provided for that.
Okay. So you had
Because,
provided that there should not be any litigation.
because we know how many flats have been sold, how many
Correct.
apartments have been sold, and we
Mhm.
have not given the possession, and the registry has not taken place. It means
Okay.
those are the home buyers. They will come back on a later date.
Correct.
The only thing, they will not get benefit of the compensation and other promises which the resolution applicant has
Mhm.
offered to the existing home buyers. Because in our plan, it was a
Mhm.
surplus company. They
Mhm.
so they had offered compensation to the claimants,
Mhm.
those who were part of the COC, because they were not part of the COC.
Okay. Okay.
Since they had not submitted the claim, they were not part of the COC. So
Okay.
there was a complete list provided. These are the home buyers who have not submitted the claim. The
Okay.
resolution applicant has provided as and when the claims are submitted, they will give, I think they have given a time of 6 months.
Mhm.
So
Okay.
that way the litigation and the challenges were resolved.
Okay. Okay.
And since the company was quite profitable, so they were little liberal in accepting the claims, genuine claims.
Mhm.
Hmm.
Right. But I think this is the same stand which NCLT asked certain in another. I'm not going to name names, but in other real estate company, the RP was directed that why, even if these applicants have not come forth, why haven't you considered it? Because they are already there in your books of accounts. So
Yes, yes,
what
yes.
you have done, I
Yeah.
think that is the same stand which NCLT has also taken in matters.
That is fair, na? That is fair.
That, that is true.
From the books of account, we can find out the list of creditors.
Hmm.
List of home buyers. Not only home buyers, other creditors also. So, so we can always submit in the RF in the information memorandum. These are the claims not submitted by the operational creditors,
Correct.
or the financial creditors, or the home buyers, or the degree holders. Anybody,
Correct.
So
Sometimes it
information.
becomes a problem in certain companies, but I think in case of home buyers, it stands on a different footing because in India, a shelter is the most important constitutional right of
Yes,
a
yes.
person
So
to have a place. And in India, that is one investment which person saves all the lifetime to buy houses. So somewhere that social angle, I think, comes in,
I think
especially in case of
we
home
can
buyers.
conclude this issue by saying that that RP has to be very meticulous in stating all the liabilities of the company, whether claimed or not claimed. There should be information memorandum should deal with all the liabilities,
Mm, mm.
and the resolution applicant also should provide for them.
See, I would not try to, you know, put it in as black and white as you have, because there will be pros and cons. Other financial traders will catch hold of the RP, and then there will be a new
No, no,
set of problems for the RP.
we are only
So,
stating the facts which we know. You
in
know,
case of home buyers, yes. In others, we have to see that
no,
I will not
no, they
make
let
such a
it
categorical
is
statement.
COC which will approve the plan. COC can debate.
But
They don't.
you can inform, but what claims to?
If the resolution applicant is providing, COC can say
It is
don't
his
provide.
choice. It
Yes,
is his choice. Correct.
it is so at least all those areas of litigation are reduced to
Reduce.
the minimum extent. You know,
Correct. Correct.
they were provided, resolution applicant said we will not pay, or we will
Mhm.
pay, COC has disapproved. Okay,
Mhm.
fair enough. So
Right.
already the issues have been dealt with.
Correct. A resolution plan generally provides that they
Yeah.
say that if there are some claims which later on are admitted, then on pro rata basis, the amount payable to each say category will be accordingly shared between whoever is admitted in that category. For instance, if there are 10 operational creditors at the time when you approve the resolution plan, and
Yes.
some 3-4 applications are pending in NCLT, so resolution applicant has to be careful to provide a paragraph to say, for instance, that today I am giving say 10,000 to 10 operational creators, but instead of 10, tomorrow if 12 are accepted by the time approval of NCLT comes through, then
Yeah.
pro rata everybody will
The
that
amount
amount
is
will be shared.
frozen. Resolution amount is frozen.
Correct.
So
Correct.
financial creditors are not adversely affected.
Correct. So coming back,
Sure.
in implementation of a resolution plan,
Prachi,
yes.
you are showing your double screen.
Oh, is it okay? Just 1 second. I will stop screen sharing then for that time. Oh,
Yes.
now okay. All right.
Yes, yes.
Thank you. Thank you.
You're welcome.
Yeah. So right now, this was one issue. Second issue, so electricity has been a problem. We have been fighting several matters here in NCLT Mumbai regarding the same thing, that electricity we are not able to get, or some of the other, they are giving some of the other excuse. But this Tata Power judgment is going to be very useful. It's a Supreme Court judgment. So even if power companies do not understand NCLT, they definitely understand Supreme Court. So I think that will give quietus to major issues which applicants are facing. The easier way to go about by a applicant, if anybody of you are briefing resolution applicant, then you should tell them to go for a fresh connection rather than just asking for a reconnection.
Yeah,
That
that is
is
better.
better. Okay. Then the second issue which companies face are when, like in Maharashtra, what you have is you have MIDC. So some similarly in Gujarat you have GIDC. So MIDC are those industrial spaces where industries come up, lands are allotted, and MIDC, if there's a change in the management, then you will have to pay certain fees to MIDC, and the transfer will not happen thereafter. Plus, MIDC on the regular basis, certain fees are payable to them, certain charges are payable to them. So in cases of companies which are insolvent, they generally end up not paying these fees for a longest time. So penalty, interest, there are some few crore rupee dues which are generally there for this MIDC and all. So this was another problem that many companies faced while asking for transfer. Even MIDC, GIDC, and all these industrial development corporations, they have regulations of how to ask for transfer. So whenever company used to come for transfer, they never used to, like in my experience, and you may correct me if you have a different experience. MIDC or these authorities do not file their claims. Even if they have pending dues, they wait till the time you seek transfer. So they have never come forward. They said, Baba, transfer from one owner to another is my prerogative. So I
And
will.
how this issue get resolved for the new promoter?
Oh, so
For, yeah, please.
no, what were you saying?
I was just asking this SRA, how SRA gets transferred in its own name. If
Transfer,
MIDC,
no,
yeah.
no. See, if there is, the thing is, one is you transfer from one company to another. For instance, in certain resolution plan, there was a provision for merger, Bhushan
No, no,
companies.
no. I am just
Uh,
asking, step into the shoes of old shareholder, old management. That
so it is change
SRA.
of management. Even if there is
Yeah,
a change of management,
yeah.
the permission is required. Otherwise, people will just buy a property and then keep on changing the management. So
And
to prevent that,
MIDC raise objection. Suppose MIDC raise objection, the new management will not come into play unless they clear the dues, earlier dues, etc. Then what is the solution and how you are dealing with such case?
in that case, you have to divide old dues and fresh dues, like future dues. If
That
there
is
are
true.
old dues, Tata Power judgment is again going to come to your rescue because it is talking about the same thing. Even MIDC, the regulation provides that unless old dues are cleared, that transfer will not take place. So you go back, show them the Tata Power judgment because this issue everybody is facing. All successful
But the
resolution
litigation
applicants are
will go
facing.
on. Litigation will go on for years and years.
So that's what
They will
in
not
this
accept because I have faced such situation in Himachal
absolutely.
Pradesh.
So these are the that's what I'm talking about the
My
problems
client,
only.
yeah,
These are the problems that are being faced by a successful resolution applicant, not at one place, but multiple applications are pending in multiple courts. And in
and the
fact,
litigation, see, in the litigation, like it is like worse than the civil litigation. Money suit or property suit, property dispute, it takes 4 years,
it's
5 years,
it's
and
much more
these
entangled
IBC
than that.
proceedings are taking more than 5 years.
No, no. Now, see, you were
I
talking about the time when the all the judges there was a no there was some vacancies in the appointments. But now, if you come to NCLT Mumbai, you will
No,
see
no, I am
that
not talking about
lawyers are
Mumbai. Yeah,
lawyers
I
are
have seen.
troubled because they have to work day and night now
No, 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 no.
because
They are very fast. They are
so
very quick. I have seen Mumbai NCLT. I have appeared before NCLT Mumbai also. But I am talking about other benches
correct,
where
correct.
my clients are facing huge problem.
No, but now everywhere there were few vacancies and that issue has been resolved. So it was a temporary issue which has been addressed now, right? So uh, so essential connections, then leasehold rights has been a problem where transfer charges and change in management they were seeking monies. So you can go back to the Tata Power judgment and tell them that though your regulations provide for payment of pending and old dues, still rest of the requirements we will have to comply with. This particular requirement, payment of arrears, will not required to be complied with. So compliance of law does not mean compliance with the law for payment of arrears, right? So this Tata Power judgment is going to come to your rescue. Now, other implementation problem which is not related to the Tata Power judgments, I will just reiterate, and then I think if you have any such experiences, you can share it. So one is regarding vendors. What happens is now in one of the cases, there are some key vendors. For instance, if it's a manufacturing concern, there are certain vendors which are crucial to you. As per the resolution plan, they get nothing. Operational creditors have got 1% or 2%, and you have written off the rest of the 99% which was payable to the operational creditors. But if you are a successful resolution applicant, and if you are giving advice as an RP to some of the successful resolution applicants, you will have to address this issue also at some point of time, that certain key vendors refuse to work with you who are crucial to the manufacturing process. You need those people who are crucial to the manufacturing process, who refuse to work with you unless they are paid. So based on their experience and expertise, they will seek payments or additional payments for whatever additional work they are doing. So just giving you an example, there was a plant. I'm not giving details. There was a plant which was to be constructed. So that plant was 95% constructed, but To start that, you needed an IP and you needed certain documentation work to understand the processes. That was 5%. So, say for instance, 100 crores were payable to this party. The plan provide only for payment of 5%. Okay. Now the problem is you need that rest 5% to make this 100% plant operational, because without that technology transfer or without that last mile completion of plant, your plant is not going to work. So this 100 crores, that say you must have paid 50 crores for purchasing this 100 crore plant, but if you have not paid, as you have not paid this vendor is refusing to pay 5%, refusing to work with you, and this plant is not getting started because of that. So this kind of issues are practical issues. I am not getting into the solutions, but I am telling you that such kind of practical difficulties also will be faced while you are implementing resolution plans. Okay. Then EPF issue has become, I think, a source of trouble for all successful resolution applicants who had not planned for it. Because now, after Moser Bear's judgment and Jet Airways judgment, it is clear that EPF dues, however old they are, all outstanding liabilities will have to be cleared. So, accordingly, the successful resolution applicant will have to deal with this aspect, right?
Can
And
government department revise their claim after 90 days? Suppose they have filed their claim within 90 days and after 6 months or 5 months before approval of resolution class or before company going into liquidation, can they file revised claim as a double amount? Like suppose they have filed 1 crore, now they are filing 3 crores or 2 crores.
you take them to Rajiv Dingra's judgment. That is what has been answered. That's what they are saying, that you cannot, because that is what happened in Rajiv Dingra. The thing is, they wanted to file a claim for the penalties. They had not calculated penalties earlier, so the department crystallized the penalties. I think the department also somewhere will have to expedite that process. Well, I myself am, I have dealt with income tax matters earlier, so they will, that process, if they are able to expedite, they will be able to file the claims and additional claims and assessments a little earlier. But if they delay it beyond approval of resolution plan, then Rajiv Dingra, Mukul Kumar, all these judgments are going to come to your rescue and against the interest of the.
No, I'm just talking about before approval of resolution plan,
Before approval also, that is answering it. No?
that
If you file it,
they will have to take approval
no.
of
See,
NCLT.
I'm giving you an example. They have filed the claim, say for instance, on the
1
100th
crore.
day.
Suppose they filed
Say
1 crore. Yeah.
claim, they file a claim on the 100th day. Okay? What does Rajiv Dingra say? The judgment says that if after 90 days anybody files any claim, RP has the power to reject.
No, no, no,
Number
no.
one,
My
it's a
situation will be,
revised claim, but you have
yes.
the power to revise and substantiate your claim. You have the power to update it. So if you feel you want to update a claim, you can do it.
No, 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 no. They are just doubling their claim. Earlier they
No,
have
they're
filed,
updating
suppose,
their claim. They're updating their claim.
yeah. So
They're updating their claim. So
so
updating, if
whether
additional documents are given,
RP is bound to revise their claim from 1 crore to 2 crores after 2 months or 3 months or 5 months.
that is a call you will have to take. I will tell you that if additional documents are given, you can consider it. But if you think the process has gone ahead, as in you are up to the approval of resolution plan stage, you can reject
Have
it.
you come across such kind of case or case law
Yes,
like?
updating claims does take place. People have updated claims, but then the timing, the facts, circumstances. See, I'll tell you, CIRP, there is no one answer. One solution fits all. Unfortunately.
Every CRP is different CRP.
So every CIRP, you will
Is
have
a
to
new
look at the facts,
CRP.
the and see, it is about lot of people. So, you know, ultimately you have to see that whatever stand you are taken is in line with what IBBI circulars say. You also have to see with what, whether you have cantankerous COC members, what kind of members you have. You have to see what is the law on the date you accept it, right? Because the law, say for instance, you are say sitting in Delhi. So NCLT Delhi may have certain decisions which you either can take advantage of or will be against you. So you will have to look at all and balance it out. There is no solution which I can give you, writing on the wall that do this and everything will be okay. You will have to take a call. But as an RP, the law provides that if additional information is given, I can give you that regulations also. Just one second. So you have a right to, under Regulation 14, to revise a claim, or if any additional information has come up, so you can take advantage of that. But then again, if it is too late or if it is filed at a belated stage, then the other creditors may take objection. So you have to be careful and you will have to see the facts of the case before you take such a decision. Okay. So I think we have covered 3 out of 4 judgment which we wanted to deal with. So we have covered all the judgments which are dealing with the claim admission, claim rejection. We have also seen post implementation problems which companies are facing, and how will the Tata Power judgment which is passed recently in September, how it will help the successful resolution applicants and the resolution professionals who are assisting the SRAs. Then now we come to the last decision, which is regarding Section 7 admission. So that is actually a good news for RPs, because more number of Section 7, if this law holds, more number of Section 7 petitions. More number of Section 7 petition. I'll just take a 5-minute break. Just give me 1 minute. Been talking for 1.5 hours, so give me like 5 minutes. Shall we start?
Yeah.
Yes, please.
Sure, ma'am.
Yes? I didn't get it.
Yes, ma'am.
Okay, all right, let's start. So, now we are moving on to the last case law, which is a judgment which has given a lot of clarity to an issue which was going back and forth because there were judgments on both sides. So, this is this Agrawal Polypack versus KK Agro Foods. I'll just pull out that judgment for you. Let me share the screen. This is this judgment. Are you able to see my screen? Agrawal Polypacks versus
Yes.
KK Agro Foods.
Yes.
This is a recent decision of NCLAT. So this decision is concerning admission of a Section 7 petition. Now, as all of you know, that Section 7 there are like if I can divide Section 7 petitions by the people who file it, we can divide it by saying bankers, NBFCs, all right. The first category is bankers who file it. Second is NBFCs who file it. Third is debenture holders. Fourth is sundry others. For instance, directors who has given loan or some private party who has given loans. So those I will consider as sundry. So these are the four categories if we have to divide regarding who are the people who generally file Section 7 petitions. We can divide it in these four categories. Okay. So, in that, what this judgment will be very useful for NBFCs, number one, and for other creditors. Because when it comes to bank, you will find that everything under the sun, they have it in writing from you. As in, with respect to banks, there will never be a problem of uh, no banks or even ARCs who have got the documents assigned from the bankers. You will never find that there is any problem with respect to documentation. They will have more than enough documentation. They will have proof after proof. They will have multiple receipts, confirmation signed from you. So in case of banks, it is rare not to find documents. But when it is private parties, say for instance, certain companies intercorporate deposits which are given, or certain intercorporate loans which are given, or holding subsidiary loans which are given, or associate companies, or friends, relatives, or third parties who are known to the company. Many a times it happens that your borrowings constitute not only of bank borrowings, but borrowings from friends, relatives, and entities associated with you. So, there, this question, this case law will be most useful because what is it that this case law is talking about? This case law is going into the basics of what documents you should attach to a Section 7 petition. Okay, so before we go on to what exactly has been held, let us understand what exactly do we have to attach in any Section 7 petition. Just 1 second. I will show you from the order itself. It is para 9 of this. It shows how will you show that in Section 7. Yeah. Para 9. So, para 9 of this judgment, this shows what are the documents that you have to provide. So if it is a bank, you will always have a financial contract, a loan agreement, a record. They will have all these bank statements by which loans have been taken. Inevitably bank loans are shown in the financial statements. So they have all these courts and orders. They will have an arbitration award or something which they have taken, wherein that loan is repayable, or a DRT certificate that amount is payable. But what about these other categories of financial creditors? So many judgments, there have been conflicting judgments of NCLT and of NCLAT in certain cases, where they wanted to understand that what documents are a sine qua non for a section 7 admission. So they have said, just let me show you this judgment. So this judgment has seen all these conflicting judgments that were there, and it has tried to bring some clarity on this particular aspect. So the first question which was raised in terms of other creditors was that when you're filing a section 7 petition, do you require to have a written financial contract? So whenever a party uh, had no financial contract which they brought on record, we used to use this judgment. And this again, as I said, banks have everything. This was against an NBFC. So Pavan Kumar versus Utsav Securities was a judgment wherein to support his submission, it was obligatory on part of the financial creditor that there should be a loan agreement in writing. So this particular case, Section 7 petition was dismissed because court took a stand and they have just provided that particular portion. Because again, coming back, Section 7 for admission, what documents are required? There have been conflicting decisions in the past. This decision, which has come in September, is throwing light on one such issue or two such issues which are there. So, what is the issue? The issue is that what kind of documents do you provide for the purpose of showing that there is a financial contract? Do you require that there has to be a loan agreement or a written agreement, or even without a written agreement you can pursue your section 7 petition? So now, in light of that, in Agrawal Polypack, what the NCLAT has done is they have step by step recorded three judgments earlier which said that you don't have a written contract, financial contract, and therefore you will not be considered as a financial creditor. Out of that, one judgment was Utsav Securities. Another judgment and other two judgments have gone, and thereafter they have taken a contrary stand, which we will come to. Okay, so in this judgment, it was this section 7 was initiated by an NBFC. The court set aside the admission of CIRP, and they said that, I think the admission did not take place. NBFC said that this matter has to be admitted. Court said nothing doing. We cannot admit the section 7 petition. Why? Because there is no transaction cannot be termed as a financial debt because there is no written contract. So RBI issued regulation to NBFC for fair practices, which states that NBFC should convey in writing to the borrower in vernacular language and all that, and the amount of loan sanctioned along with terms and conditions. So NCLAT said that we cannot allow your section 7 petition to be admitted. Why? Because of this reason. Because the law provides that you have to take it in writing. You have not taken it writing. This is a mandatory requirement. And loan agreements, look at the last line. I'm just highlighting the last line. This was the earlier NCLAT order which has been set aside by this order. Okay, so it is obligatory on part of financial creditor that there should be a loan agreement in writing only. So this was one such judgment in the past which was creating a lot of problems. The second judgment was this Prayag Polypack. Prayag Polypack, there are two judgments in Prayag Polytech matter. One judgment is Prayag Polytech versus GEM, where again TDS was shown. What the financial creditor did was he relied only on a TDS certificate to show that look, there's a TDS certificate. In the TDS under section 194I, interest has been, the TDS on interest has been deducted. So that means that they were deducting TDS. That means interest was booked in their books of accounts as an expense. That means I am a financial creditor. They have shown my amount. They have shown this TDS deducted for interest, and they have given me a TDS certificate. I have the TDS 26AS to show it. Court said merely on the basis, and this fact is important because this has been distinguished by this judgment. This judgment said that merely if you show me the TDS deduction, I will not be able to accept your Section 7 petition. For maintaining a Section 7 petition, you will have to show me something more than just a TDS that was deducted. That I cannot accept. You will have to show me a financial contract. I cannot accept just this document. Okay. Then, and this Section 7 petition was not accepted, it was rejected. Then we come back to the third judgment, which again has been distinguished in Agrawal Polypack. That is the Prayag Polytech versus Bond Loan Petrochem LLP. In this judgment again, the court said that you cannot establish disbursement on the basis of an alleged agreement. You cannot establish default on the basis of oral pleadings. You will have to show me some documents. And here again, they have tried to say that documentation is essential when I am putting a company into the CIRP process. Okay. Balance sheets were shown. Balance sheets is a good document which can be shown, and that has been admitted. So this aspect they have not labored on the aspect of balance sheet, but they have said, and I'm just going to the last paragraph and then I will take you through the judgment, and this is what is most important. Please read the portion which I am going to. Look at the portion which is highlighted. So, adjudicating authority took a view that there should be a financial contract between parties which elucidated the rate of interest and date of repayment. Adjudicating authority took a view, this was the lower court's judgment, which this authority has set aside. So, in this case, NCLT had taken a view that there is no written agreement to establish the nature of transaction between parties, and therefore appellant has failed to prove the debt, and therefore they had dismissed the Section 7 petition. However, in this particular Agrawal's Polypack case, court has said that we have already held that requirement of written financial contract is not a precondition for proving a debt. So in white and black, the court has said that agreement, financial contract, can even be a oral contract provided you are able to show the terms. So, what is the court said? We have already held that requirement of written financial contract is not a precondition for proving debt. So this gives a quietus to this issue that do you require to show a written agreement? They have said no written agreement is required. There are some conflicting decisions. They have distinguished it. Said no. The stand of NCLAT has always been that written financial contract is not required.
Even contract law also says the contract can be orally also. So
Correct.
they are.
And yes, absolutely, and that is what they have said.
What about IU? The requirement of IU has become mandatory now.
Yes, IU they are requiring it now.
So if
Without that,
if record of IU is not showing, then we cannot file.
No. That just because IU record doesn't show, see IU you have to show in a Section 7 petition to maintain your petition. But in IU, if they dispute, that doesn't mean that you cannot file your claim, Section 7 petition, and that is because of this particular. This is because of this judgment only. Because here, if you see, I'll just go to para 9 again. Yes. So para 9, just read. Regulation 8 has been extrapolated here, which is very useful. It says records of information utility or, okay, this word is very important, or other relevant documents including financial contracts supported by financial statements as evidence of debt, or a record evidencing that amount committed by financial creditor under a facility has been drawn by the corporate debtor, financial statements showing that debt has not been paid, or an order of the court that the adjudicated amount has not been paid. So, if you are able to show any one of these five things, you will be able to sustain your Section 7
Yeah.
petition.
If there
A
is no
written,
direct evidence, then corroborative evidence
yes,
can work here.
yes. And that is what has happened in this particular case. I will just show you the facts of this case, which will give you an answer. So, in this case, they went to the corporate debtors balance sheet. They said, look, balance sheet shows that amount is payable, right? They said that your long term borrowing show that from this particular entity there is a loan which is currently standing in your balance sheets. So that is the first proof that yes, a loan has been taken.
Suppose there is
Then,
no interest. It's a loan has been given on zero interest. Then
see,
time
in this particular case, they have said that time value of money and everything is important. But if you see orator marketing, if you have not charged interest, you go back to the orator marketing judgment, which says that it says interest if any. So even if no interest is charged, you
yeah.
can use the orator marketing judgment. Okay. So in this particular case, they showed this entry, they showed this particular notes in the balance sheet, which says repayable or demand. So they said that what are the terms of financial contract? It is evident from the balance sheet itself. They are showing the amount which is pending, and they are showing that it is repayable on demand. So this is the term for the payment. This is the financial contract. So based on these two, they have accepted the amount, and I think the TDS aspect was also there. TDS in itself is not enough, but TDS combined with say a balance confirmation, or TDS combined with you all know this Blue Noir Gajendra investment versus Blue Noir judgment, where NCLT Mumbai had held that, and up till the Supreme Court, this matter has been taken up till the Supreme Court, and it has not been negative. So that particular judgment clearly says that TDS itself is not enough. But if you read the word, TDS in itself is not enough. But along with TDS, if you are able to show other corroborative proof, for instance, your balance sheet shows that the loan, or you can show interest is actually paid, or if you can show a balance confirmation. So, along with that, it is a good enough proof if you are able to corroborate it with other documents, right? So this is the judgment of Agrawal Polypack. One more answer, one more issue which they had raised was regarding Section 186. I'll just show that regarding 186 of Companies Act. But this issue has not been clear cut answered in this case, because they said that there is no non compliance of 186. So they have just said that we are of the view that there is no one non compliance of 186. So this issue is still open, that if in other matters you say that Companies Act requires certain permissions to be taken, and because those permissions were not taken, this Section 7 petition cannot sustain. This order has not given any clarity on that. So that defense, if you are advising certain corporate debtors, perhaps that issue is not answered in a clear cut manner in this judgment, you can take up those issues. Now, in one of the cases, if I just may give you an example, there was a friendly loan taken. All right, friendly loan taken from say Mr. A by the company. Now, Mr. A, after this loan had been taken, the company took a loan from a bank. So Mr. A gave an undertaking to the bank, not to the corporate debtor, but to the bank, that I will not seek return of this loan unless this entire amount is paid. Because bank generally require that undertaking, that old debts which are standing, all financial debts which are standing in your books, you will not seek return of these loans. So now this financial creditor comes up before this repayment of this loan and says that return the money. When I raise this defense that look, you have given an undertaking to the bank that you will not ask for the return of this loan, they make a statement that that there's no privity. That undertaking is given to the bank, not to me. So this kind of issues, like in section 7, now with time, certain defenses are there, which you can of course raise if you are advising the corporate debtor. But this issue regarding just TDS, like TDS cannot be a good enough proof, or there is no financial contract in writing, all these
Such
will
kind
not
of
work.
mistake is of like draftman. It's a draftman has committed such kind of mistake, like not making tripartite agreement and making a bilateral agreement and keeping
But
aside
nobody,
the main.
see, I'm telling you, when the going is good, nobody considers all these documents. Only when people start fighting, they look into the
Yeah,
fine print. So that time, in good times, you will say, "Kya, what is the
time
thing?
in
Okay, you do it in 2 minutes." Okay, okay. So
while
the,
entering into agreement, it's a honeymoon stage, and
correct,
thereafter.
correct. True, true, true. So, in terms of form, just 1 second. In part 5, when you are filling form 1 and you don't have an oral contract, in one of the cases we won on that point. So, I'm just giving you a heads up when you're filing a Section 7 petition, that latest complete copy of financial contract reflecting all amendments and waivers, attach a copy. So, in case you have an oral contract, what people do is they say not applicable, but you require financial contract under section 7 to have a section 7 petition to be maintainable. So in that, when you recite no or not available, you somewhere, if you can use this against a section 7 petition. So be very careful that you are filing a section 7 petition based on an oral contract. At least try to put in those terms which according to you are the accepted terms in this particular para 5. Okay, because here you give those details of the financial contract. Say for instance, you are given a long term loan, this loan is repayable on demand, or this is the interest based on certain documents which are available. So those terms of financial contract, even if it is an oral contract, you should ideally put it up in this para 5 and not leave it blank. Okay, because if there is a difference between what your synopsis says and what this particular paragraph says, that can be used against you in a section 7 proceeding. So with this, I think we have covered all these 4 case laws which are recent September judgments. And with this, I think from my end, I have completed my, I think, monologue, if I may say so.
Your two screens are showing now. You can
Okay, just 1 second. Let me stop sharing the
now
screen.
it's okay.
Yes. So,
Thank you.
with this, thank you very much for a patient hearing. If there are any queries, you can put it up. I don't think any queries are there in the chat box. So, I think with this,
No, it was not monologue.
I'm
We participated.
yes, yes, you did. It was a, it's good to share ideas. It's easier for the
Yeah,
speaker also, and it is fun. It's more fun that way. So
yeah,
absolutely, thank you so much
yeah.
for a
Thanks a
patient
lot. Yeah,
hearing, and
Thank you,
thank
Prachi ji. Thank you.
thank you.
yes,
Thank you, Prachi.
Nice session.
thank you so much.
Thank you very much, ma'am. The session was very interactive and insightful.
Thank you so much. Thank you so much.